let's just say, a family have split up, mum and dad have split up, and then they had a will before, and now one of the partners has got another partner, and then dies, and then they're contesting the will because they haven't cancelled the original will that they had with their previous partner. They forgot all about it. So what would happen in a situation like that?
Well, it's a very, very good question, because these days many families are more fractured and franchised out. You've got kids from one relationship and then kids with another relationship, or as you rightly said, there's all kinds of history, and I call it baggage. I don't mean to be offensive in any way, but that's what I would say. So things happen such as divorce. If you divorce and made a will, the divorce will cancel that will without you needing to do anything. Likewise, if you've made a will and you marry, that will cancel the provisions of that will. So there are two things that happen in life naturally: divorce, marriage, or marriage, divorce, whichever way you want to start it off. And the act of the marriage or the divorce will cancel as well. So you can overcome that by making a will in contemplation of these events. So you would have to have a clause in there. That's why people wouldn't know that, because people can go to W.H. Smith and they think they buy one of these wills for 20 quid and they've got to fill it all out themselves. Well, I put it to most people, they won't know about the clause if they're getting married. So you have to put a clause in that would say, I'm contemplating marriage, I'm getting married, and I'm making this will with that contemplation in mind. Fine, that will survive. Or I'm making a will because I'm going through a divorce process, and I'm in contemplation of that divorce, I'm making a new will because I found somebody else or whatever. Because all these things, the divorce certainly can take a long time, it can be contested, and it's not meant to stop you gaining control, because a will, as I said before, puts so much structure in your in knowing what's going on. So if you've got two options usually when you're with somebody. A mirror will, so both of you are saying the same provisions. So a lot of people will say, my children, so if they have children not together, they've got historically children, two of each from previous relationship, then they can specify in that will that they are in knowledge of the fact they have different children, that a certain amount of the estate, could be 50%, it could be 75%, it could be 25%, it's all dealt with percentages, goes to the children first, and then what's left over to my husband,
right,
and vice versa. There's a mirror will, so they're very much, so basically apart from changing the name of the testator or testatrix, the female is the testatrix, testator is the male, they're virtually the same, because there'll be the same names in there. A mutual will is more of a contractual binding one. That, when you've made that can't be changed. So it doesn't matter who you've married in the future, and you might marry some sort of gold digger, or you might marry, whichever, that goes for males or females. That will is contractually binding going forward to whatever events happen.
Right.
It's not many of them are made, but if you've been together, let's say for 30 years, and you say, look, we've all had children, we've had these children, and we were to make a mutual will, then whatever happens, if he marries or she marries somebody again,
right,
the provisions that she's put in place for their children are binding. And when I say binding, they're contractually binding. So yes, of course, things can change and somebody can take, but there's a cause of action to go to court and say, hang on a minute, this piece of paper that was made 10 years before or whatever still stands. So those, they're very good, but you lose the flexibility.